Let's review where we've been so far. Last time we talked some about remedies, so what it is that you can get from a court. We talked about specifically substitutionary remedies, which come in both economic and non-economic forms. So these are remedies that are meant to, as the saying goes, make the plaintiff whole through money. Now, of course, you know and I know that nobody can be made whole through money if they've suffered some harm, but that's what the law offers, and so that's what we say. Note that non-economic damages, as these are called, are still substitutionary in the sense that you don't have to be able to provide specific receipts to claim damages. So we talked last time about pain and suffering, emotional damage, that you can provide evidence for through affidavits, through witness testimony, and juries will evaluate that, and it's quite typical to grant money damages for non-money harms. We talked about punitive damages and the fact that they're really only available for particularly egregious, reckless, or deliberate conduct, and they're basically not available in contract cases at all. We talked about declaratory judgments, which are basically statements of law without any further recompense to the party. And then we talked about this set of remedies that comes from the law of equity. So a traditional separate branch of law where people could ask for assistance or remedies that were not available at common law. So the most prominent ones are specific performance in contract, so make the contract breacher do what they originally promised to do. Replevin, which we saw in Fuentes, right? But that's an equitable remedy to say, oh, you took my stuff, well, I'm going to not make you pay for my stuff, but actually give my stuff back, because maybe what I'm interested in is not the value of the stuff, but the stuff itself. You know, maybe it's like my grandmother's whatever, special metal hanger or a painting that I want or whatever it is. And most commonly, an injunction. So a request to the court to force somebody, to order somebody to do something or to refrain from doing something. So we talked about one particular kind of injunction, the preliminary injunction, which is particularly weird because it's something that a party requests from a court before the court has ruled on the merits. So we don't know who's right and who's wrong yet in a legal sense. We haven't reached a final judgment, and yet we're already asking the court to order people to do things. So I say this is always a judgment call, and then I have in parentheses, that's the nature of equity, because equity, in a sense, is a branch of our law that requires judges to exercise their judgment as part of the standards that they apply. So there is never going to be a bright line rule for an equitable decision. This is a place where judges have to consider broad values. So let's review the standard that courts use to evaluate preliminary injunction. So one thing they have to consider is, or one thing they have to determine in order to grant a preliminary injunction, is that in the absence of an injunction, the party seeking the injunction will suffer irreversible or irreparable harm. Another thing they have to determine is that the party seeking the injunction is likely to win the lawsuit in the end. So note how odd this is. Usually we ask courts to refrain from making any kind of determination about what's likely to happen at the conclusion of the lawsuit until the lawsuit concludes. But here we're asking them to kind of guess based on whatever evidence the parties are able to present when the party asks for an injunction. We're asking the court to guess, well, who's going to win on the merits in the end? And if the party seeking the injunction is unlikely to win on the merits in the end, then you can't grant the injunction. The court also has to determine that the injunction is in the public interest. So this is a real sign of equity. When you see something, when you see a test that asks a court to determine whether something's in the public interest or that brings up public interest, that's going to very likely be stemming from the law of equity, because this is exactly the sort of general kind of values-based, rather abstract, not specific kind of determination that we ask courts to make in equity. And finally, this is the one that is puzzling because of the way it's often phrased, but I think we got at the basic meaning in class last time. We want to find that the balance of equities tips in favor of the party seeking injunction. And what that means is basically that having an injunction will cause less harm than not having the injunction, or as I've written it here, the requester's interest in having an injunction is greater than the opposer's interest in not having it. Okay, so preliminary injunctions are a real demonstration, I think, of the way that this kind of vague, all things considered, very values-oriented quality of equity endures and in fact is really important in our current law, even though we sometimes talk about our current law as much more based around bright line rules and looking for tests and stuff like that. This kind of standard that we have for preliminary injunctions is not at all unusual. And it kind of demonstrates the power of the court, and then also the ways that courts consider how they're supposed to use that power. The other thing we talked about last time was the due process requirement in the Constitution, which appears twice, once in the Fifth Amendment as applied to the federal government, once in the 14th Amendment as applied to the states. It prohibits a government from depriving anybody of life, liberty, or property without the due process of law. And Fuentes v. Shaven is our first case that explores what it means to have due process of law. What does that phrase mean? What Fuentes v. Shaven determined is that under the Due Process Clause, in order to have due process, parties whose rights are affected are entitled to meaningful notice and opportunity to be heard. And what meaningful means is that you have time to prevent the deprivation of life, liberty, or property. So you recall in Fuentes, Ms. Fuentes was given notice as the sheriff walked in the door, right? She was told, "Hi, we're here, we're taking your stove." The court determined that that is not sufficient notice, that's not meaningful notice, because it doesn't provide her with an opportunity to put on her case and prevent the taking of the stove. And the court also determined that providing her with a hearing later on, so taking the stove now and saying, well, you can go to court later and see if you can get it back, is insufficient, because what the Constitution prohibits is a failure to adhere to due process of law. And so if the arbitrary taking has already occurred, the constitutional violation has already occurred. And you can't have a law that allows a constitutional violation. Why can't you have a law that allows a constitutional violation? This is something that I think many of us assume as background, but like most other things, it has to be grounded in some legal grant of power. And in this case, that grant of power is the Supremacy Clause of the Constitution, so Article 4, Section 2, which says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof," so federal laws, laws of the United States, not of any particular state, that means federal laws. So the federal Constitution and the federal laws that are made under the authorization of the Constitution are the supreme law of the land. And nothing in any state constitution or state law can contradict it, can be upheld as contradicting it. So the reason that the Supreme Court can invalidate the replevin statute of Florida and Pennsylvania is because it finds that those statutes do not conform to the requirements of the federal Constitution, and so they fail under the federal Constitution. Just a quick note that if the replevin statutes were in court not under judicial review, but under statutory interpretation, if we were interested in what those statutes really mean, say there's some ambiguity about what the process is supposed to be, that is something that the Supreme Court doesn't actually get to determine. It doesn't get to tell states what their laws mean. That's something for the state legislature and for the high court of that state. What the Supreme Court can tell you about state law is whether it violates the federal Constitution or not. So these are divided powers among the federal government and the state governments. All right, but how do I know if I got sufficient process? So in Fuentes and Matthews, in that movement from Fuentes to Matthews, what you see is a very typical process that you'll see over and over again of the court, or the courts in general, building on and changing their interpretations of the law as time goes on. And so you have to remain alert to that, because at this point, if you come in and say some procedure violated due process because Fuentes, your adversary is going to say, but what about Matthews? Because Matthews has set how we evaluate due process now. That doesn't mean that Fuentes is irrelevant, but it means that it becomes kind of one layer in the sedimentary accrual of law that is how our system works. So Fuentes gives you the ideal, the kind of abstract goal of notice and an opportunity to contest. Matthews gives you the standard by which you evaluate whether notice and opportunity to contest were sufficient in a particular case. And that is a balancing test that asks, how important is the thing that plaintiff is being deprived of to plaintiff? So how important is your bicycle or your stove or your welfare check or your Social Security disability insurance payment, which is what Matthews was actually about? Then think about the likelihood that the deprivation is erroneous and the value of additional procedural safeguards. So think about our Darrell and Jane example. How likely is it that Darrell and the police officer are wrong about the bike in Jane's garage belonging to Darrell? What's the likelihood that they're taking her bike erroneously, wrongly, and it actually belongs to her? So that's on the one hand. And on the other hand, when we think about procedures we could use to prevent error, how much error are those procedures going to prevent? Is this a situation where there's not a lot of error and additional procedures aren't going to make things much more exact? Or is this a situation where there's a lot of room for error and additional procedures are going to really bring that error rate down? Or I guess you could have a situation where there's a lot of room for error, but there's just not a lot of good ways of finding out what the real situation is, and so it's difficult to bring the error rate down anyway. This is the kind of weighing that you're doing at this step of the Matthews test. And finally, you want to think about what's the burden on the government of those additional safeguards. So say we have a way of conclusively, say we can do like DNA testing on the bike and figure out conclusively, I mean, that's completely absurd, right? But say there is a way to figure out conclusively whose bike it is, but it's extremely expensive. And so in every case, we're going to be spending more to figure out whose bike it is than anybody would ever spend on the bike itself. And it'll be tying up a lot of resources that could go to, making sure that bikes aren't stolen or tracing down stolen bikes. So how would the how would the inevitable and ubiquitous resource constraints on the government fare under this increased procedural safeguard? So note how far we have come from Fuentes. This is not notice and an opportunity to be heard is an absolute necessity before any deprivation can occur. This is much more conciliatory toward the needs of administration and government and its resource constraints, right? Maybe sometimes people don't need notice and an opportunity to contest because their private interest is not that great. The burden on the government would be too much. The likelihood of erroneous deprivation is not super high, and additional safeguards wouldn't really do much to reduce the error rate. So this is much more, I don't know, do you want to say wishy-washy? It's much less adamant than Fuentes is. This, however, is the current test for due process. So if somebody says, my due process rights were violated, this is how we ask whether they're right or not. So this is our first time talking about constitutional protection. So let's just pause for a minute on them. Due process is a constitutional requirement, and so it always applies. There is not going to be a situation of somebody, well, that's an overstatement. There's usually not going to be a situation of somebody within the United States, so where the Constitution applies, who is deprived of life, liberty, or property without any process at all, and a court will say, well, they didn't deserve due process. The reason I say it's an overstatement to say there never will be such a situation is because in the immigration context and at the border, due process protections are much more wobbly and don't apply with the same strength according to our case law. So that is a situation where actually you do see courts saying that person doesn't deserve due process to begin with, so we don't need to evaluate whether they got enough process. But let's put that to the side for a sec, because what I want to point out to you here is the way we talk about constitutional protections in court. The way we talk about due process is it always applies. There's never a situation in which you'd say, this person doesn't deserve due process. But you will ask, how much process is due in a particular situation? What do you deserve? What kind of process do you deserve? And that's where Matthews v. Eldridge comes in. You determine how much process is due in a particular situation. So what I'm showing you here is a little bit, it's the doctrine, but it's also a little bit of the rhetoric that we use to discuss these things. You can argue that in a particular situation, a particular plaintiff deserves diminished process, but you can't argue it in the language of they don't deserve due process to begin with. You argue it in the language of Matthews v. Eldridge, which says due process doesn't always require the exact same thing. You can have, there's kind of a sliding scale, there's a flexibility in determining what process is due. And I think the car towing case that you guys talked about at the end of our last class is a really good example. It's okay to have to tow a car without a hearing because of the Matthews test, because the costs basically outweigh the benefits of doing that. So I'll end on this slide, and just to emphasize, what we're talking about here is both the doctrine and the argumentative structure that you need to take as a lawyer when you're arguing these things in court.